welcome. We may have a few people joining us late, but thank you so much for coming. For those who don't know, my name is Amanda Carling, and I am Métis from Manitoba, a descendant of the Red River Métis. I am also the manager of Indigenous initiatives here at the Faculty of Law, which means, among many other things, I have the great privilege of getting to pick who to invite to be part of our Indigenous Initiatives speaker series. And I've had my eye on Dean Angelique EagleWoman since last year, and I'm so grateful that she managed to make it down here today. Before I introduce her properly, I'd like to acknowledge that we are on the traditional territory of many different nations. Historically, this land that we now call Toronto has been the home to the Huron-Wendat, the Seneca, the Petun First Nations, and the Mississaugas of the Credit River, among many, many others. And of course, we know, because we have Indigenous students from across Turtle Island who are in this room today and in this school, this really is a meeting place and a gathering place where we come together to learn about each other's traditions and learn how we can move forward as a country in a good way. And I think this is really exciting for me because personally, I know very, very little about what is happening south of the border, and I had the opportunity to sit with the dean and with some of our law students for the last hour, and it occurred to me, being from Red River, that probably I'm more closely related to the dean than I am to people who are on this land, and I'm in Anishinaabe territory, often learning Anishinaabe words, learning Haudenosaunee words, and working within these traditions. And yet I know nothing about my neighbors south of the border, except, you know, I probably drive past your community going to the Mall of America as a kid, or for a hockey tournament or a soccer tournament, that kind of thing. So I'm so excited to get to learn about this, and so grateful that you joined us. Angelique EagleWoman is the first Indigenous Law Dean in Canada, which is amazing, but also, like, how long did it take, right? She's also the second Dean of the Bora Laskin Faculty of Law, which is at Lakehead University in Thunder Bay, Ontario. She is a citizen of the, and apologies for the pronunciation, Sisseton-Wahpeton Oyate of the Lake Traverse Reservation in North and South Dakota. Her career has spanned serving as General Counsel for her Indigenous Nation, serving as a public defender and as pro tem judge in various U.S. and Indigenous courts, and working with law firms in Washington, D.C. and in Oklahoma. Prior to her decanal appointment, she spent 10 years on the law faculties at the Hamline University of Law in St. Paul, Minnesota, as a visiting professor at the University of Kansas School of Law in Lawrence, Kansas, and as the founder of the Native American Law Emphasis Program at the University of Idaho College of Law in Moscow, Idaho. Her primary areas of scholarship include tribalist economies, international indigenous legal principles, and indigenous governance. She's the co-author with Dean and Professor Stacy Leeds of the Cherokee Nation of Oklahoma of the book Mastering American Indian Law. She's written extensively in law journals and reviews on raising the quality of life for indigenous peoples in North America. We're very, very lucky to have her, in addition to all of the duties that go with being the dean, which are not always very sexy duties. She's also teaching 3 classes at Lakehead right now. So it is incredible that you made it here. She flew in this morning and she's going back home this afternoon. So please give her a warm welcome.
Thank you. Thank you very much. In my language, we say Wambdi A. I am thankful for that warm introduction, and I'm happy to be here. So Amanda's been after me for a year, and I honor my commitments. I said I'd come speak, so here I am, even though I taught 2 classes yesterday. But I'm talking about something I'm really interested in, and this is something, so let me talk a little bit about who I am. So I'm a Sisseton-Wahpeton Dakota woman, and our people are the Oceti Sakowin, the 7 council fires, were the Dakota, Lakota, Nakota people. And our people span Turtle Island. We go across many states in the United States, and then also up into Manitoba and Saskatchewan. And so our perspective and the perspective I was raised with wasn't about political boundaries. It was about our people engaging in relationships. And so this talk is going to be about my immersion now in Canadian law and looking at the relationship with Aboriginal peoples, and also the conversation that's been going on between the British Crown and what becomes the United States, and how those principles have influenced Canadian law, and also what may be borrowed from U.S. federal Indian law to move the conversation forward in Canada. And so the place I'm entering this conversation from is this idea of envisioning First Nation community courts. So in the United States, we have tribal courts, and so that's what's behind this presentation, is looking at building this kind of relationship here. So let's first start talking about First Nations and the beginning relationships with the British. So confirming the nation-to-nation relationship. We often talk about a pendulum swinging between recognizing First Nation sovereignty and then not recognizing First Nation sovereignty. So at the beginning of the relationship, there was definitely a recognition of First Nation sovereignty. When you enter into a treaty, that's between international parties. Nation states is the term used today. So this treaty relationship was symbolized on both sides. On the British Crown side, it's a text, it's a document. And we've seen, if you've been looking at Canadian Supreme Court decisions, a progression between looking at just the text and the literal interpretation of that text, and understanding that when you have any type of agreement, you have to know what's happening in the minds of both parties. And so in terms of the First Nation parties, there has to be the oral histories, the understandings that come with the treaty agreement and relationship. It cannot be based just on the literal text. So you can't read a treaty and say, I understand it. There's an interpretive, a necessary interpretive model that has to go with what does this treaty mean. And that requires, if it's going to be in a court system, extrinsic evidence coming in. And this is something that's progressively happening. If you look in the early cases in Canadian law, you don't see that. You see a very narrow reading of treaties. But one thing that has continued to be narrow in Canadian jurisprudence is this idea that the treaties are the document that describes the powers and authority of First Nations, which is strange. Which is strange, and is something that I'm going to be talking about through this presentation, that you don't enter into an agreement with another people and then say, I surrender the status that gave me the ability to enter the agreement, right? And so in Canada, you're often talking about, you start the conversation with, where's the self-government piece? And I'm going to talk about how in the US, that conversation was assumed. So sovereignty is assumed. And we'll look at how it's also been entrenched legislatively. But back to the Royal Proclamation of 1763. So you can't understand the Royal Proclamation without also looking at the Treaty of Niagara of 1764. So at the Treaty of Niagara, you have over 24 First Nations represented. This is before there's a political line, so they're from Turtle Island. Some eventually were on the US side, some on the Canadian side. And you have the memorialization of it happening in two ways. One is the text, and then the other is the wampum belt. And I'm going to tell you, with the wampum belt as well, this is a two-row wampum, you cannot literally read it, right? You have to have interpretation of what that means. If you literally read it, you would say you have white beads and purple beads in two lines. That is not going to give you the sense of what that means. It's two people living on parallel paths with their own jurisdictions, not interfering with each other's internal relations. It's on white for purity of intent, good faith. This was what commemorated the Treaty of Niagara of 1764 and the relationship with the British Crown. is seen as sacred agreements. So from the indigenous perspective, when we enter into these relationships, and there's also a context here that happened prior to the British Crown coming into the picture or the French, where First Nation to First Nations had agreements. And so there's a whole context and history that has to be brought into treaty interpretation. But when you enter into a sacred agreement, there's a ceremony that goes with it. And we often use our sacred pipe to bind that ceremony. And so in today's terms, when we talk about treaties, there are people that say, well, is there an option to disregard the treaties or to no longer uphold the treaties? And I think it's almost universal among tribal nations and First Nations to say that no matter what happens in the relationship, the agreement that we made was bound by the divine. And so when we made this relationship, we entered into ceremony, and our sacred promises are with the Creator as well. And so I think a lot of First Nations and tribal nations stand on the honor of we've kept our relationship, we've kept our promises, and we feel that we have to. We see right now in the jurisprudence in the courts that there's a progression since the 1980s of a discussion of honor of the Crown in interpreting treaties, which is good. So bring it up to both levels. Everyone honor these as sacred agreements. So we start there. With the Royal Proclamation of 1763, you see the British Crown putting in language of protection of Indians, talking about making agreements with assemblies of Indians, so there's that recognition that there's governance happening. You also see the beginning of a systematic way to dispossess Indian title, but you also see a government that's just ended a war and doesn't want to get into any more wars, telling its subjects, British subjects, to respect Indigenous title, land, hunting grounds, don't survey, don't squat, don't do these kinds of things. So the relationship is nation to nation. We're going to uphold our side, you uphold your side, and for the most part, that's happened. And also the recognition, of course, of self-government. Engaging in treaty making is an activity between sovereigns. This is the number of treaties from 1 to 11, went from 1871 to 1921. And I'm just reinforcing this idea that there was no agreement by First Nation people that they were going to be an inferior government on any level with the British Crown. It was the British Crown coming to the First Nations to ask to enter into agreements. It wasn't First Nations going to the British Crown and saying, we really should have an agreement here. So the balance of power in these early days was very much recognition of the Indigenous right to self-determination, cultural practices, governance. And also, I will say that as the treaties are negotiated, the British and eventually the Canadian officials begin to use the protocols that they learn from First Nation people. So even at the Treaty of Niagara, you have a wampum belt being presented by the British officials, the covenant chain of friendship. So understanding that this was a way to make an agreement. For First Nation peoples, a lot of our diplomacy is around ceremony and also gift giving. So this reciprocal relationship. If you offer gifts, you come in a friendship way, and everything for us is about kinship and interdependence. And so when you talk to elders about treaties and interpretation, they're going to talk about we agreed to have a kinship relationship. And you'll often talk about the treaties being talked about as part of the oral tradition, and this idea that the leaders told the people that they were in the treaty relationships with, we will instruct our children, our grandchildren, and our great-grandchildren to follow these promises we're making to you today. And the expectation was that that was happening on the other side as well. And what we're going to see is a pendulum swing from this nation to nation to an assimilation system. So self-government has to be talked about when you're talking about courts. And again, I really want to enter the subject through looking at court systems. So with Confederation in 1867, Canada was took on the responsibility to uphold the treaty obligations and agreements. And unfortunately, Canada didn't do a good job of that. We see the Indian Act passed in 1876, and this severely limits the ability of First Nations to govern. It breaks up Indigenous nations into very small groups on very small lands, and then layers over that very minimal ways of governing with an Indian agent appointed that could veto anything, could decide not to hold council meetings, just unchecked power over what's happening on the reserve. And this is still in effect. So when we talk about that pendulum swing, we went from sovereignty upholding First Nation government to basically annihilating and controlling tribal and Indigenous and First Nation government, and now it needs to swing back. It has never swung back in 250 years. So that's what I'm talking about, is swinging this pendulum. I'm sure you're all aware in 1982 with the Constitution Act, Section 35(1), this verbatim the wording, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Well, existing Aboriginal rights should include self-government. How do you say that you entered into treaty relationships without saying that there's a government to enter into those relationships with? But that is the conversation happening now. And there's very narrow reading of what Section 35(1) is on Aboriginal rights. There is a modern treaty I want to talk about, the Nishka in 2000. And what we see is as self-government is being asserted, courts are in the conversation. So it provides for a Nishka court. However, the court is under the supervision of the Provincial Court of British Columbia, and the appeal structure is through provincial and federal court. And I see that as maybe a first step. So I'm going to talk about there are first steps here, but I think that there needs to be a realignment back to the First Nation communities, and that's why my title is First Nation Community Courts. So there are self-government agreements that are being entered into, but they're said not to be viewed as constitutionally protected under Section 35(1). So somehow this idea that Aboriginal rights don't include self-government is still very much within the conversation. So I wanted to point out a few self-government agreements that have recently been concluded. So for the Tlingit and the Yukon, there's a justice agreement with a peacemaker court. But again, we're seeing appellate review. A higher court can overturn those decisions coming out of the community. Here's the Supreme Court of the Yukon Territory. The Sioux Valley Dakota Nation in 2013 entered into a self-government agreement, and they haven't implemented this yet, but they have the ability to establish a court. Again, we see this with appeal to the Manitoba Court of Queen's Bench. So the self-government agreement process hasn't been the best way forward. Lengthy negotiations, we're taking decades to do this. Also, for First Nations to engage, they're usually coming from an underfunded position, no resources, so they have to take out reimbursable loans from the federal government that are paid off the top of the self-government agreement. And then also one of the hard bargaining positions that's been taken for these agreements is that there must be a surrender of title and extinguishment as part of the federal negotiations. So these are by no means the best way forward, but it's, again, talking about first steps with courts coming out of them and the idea of courts. So I want to take a step back and talk about Indigenous views on dispute resolution. So going back to those existing Aboriginal rights, those existing ways of governance, our worldview is to bring things back into balance. If you harm another person, property, that's harm to the community. And so the idea is to have responsibility over that, and we would always have community involved. So if we have someone that has acted out for some reason, what we would now call a crime, we would bring together families and find out what were the issues happening in the person's life, and we would have a remedial plan. What are the responsibilities that they could take on? So I'm going to give you an example. So there's a famous case in the U.S.
Half of that screen.
Oh, it jumped. There's a famous case in the U.S. coming out in 1890. It's called Ex parte Crow Dog. So Crow Dog was a Lakota, and his nephew was Crazy Horse. I'm sure you've all heard of Crazy Horse, Tashunkawiko. And and again, we had these large kinship networks. Another uncle of Crazy Horse was Sintagleshka Spotted Tail. And Spotted Tail was at the Rosebud Lakota Reservation. I have Rosebud heritage as well. And Spotted Tail was very handsome. And Spotted Tail had multiple wives. And apparently Spotted Tail wooed one of Crow Dog's wives away. So Crow Dog was not happy with him. But then Spotted Tail also was in favor with the Indian agent and government officials. And Crazy Horse had sent word that he was in the Black Hills. It was wintertime. He wanted to come home. He wanted to come back into the village and be with his family over the winter. Would it be safe to do so? Spotted Tail said it would. Spotted Tail knew that actually if Crazy Horse came in, he'd be immediately arrested. Crazy Horse comes in, he's immediately arrested, he resists, and he's killed by the cavalry. So that was it for Crow Dog. Crow Dog said, you know, you've blemished our honor too much now. He also had his personal issue, and he killed Spotted Tail. The U.S. government was not happy. Spotted Tail was helping some of the Indian agents with the things that they wanted to do. And so Crow Dog was brought up for charges in the Dakota Territorial Court. This is before there's states in this area. And he was arraigned, and they said, you need to come back for sentencing in 9 months. And he said, okay, I'll be back for sentencing in 9 months. And there's lots of scholarship saying that normally settlers who would have something similar would never show up again. Crow Dog came back because he said he would. So he came back, and they wanted to hang him, but the case gets appealed. And it gets appealed to the U.S. Supreme Court. And this is the decision in 1890, and the U.S. Supreme Court says we have no jurisdiction where Lakota and another Lakota have an interaction in their homeland. There is no basis for jurisdiction. Unfortunately, this changes. The next year, people lobby and foment, and the Major Crimes Act is passed, and federal jurisdiction for certain felonies is passed. But back to Crow Dog. So Crow Dog isn't hung. And so Sintagleshka's family comes forward, and this is happening outside the court structure, right? And says, you know, you've done this, you've caused a disruption in our family, and he has these wives, and so Crow Dog, here's what you're going to do, and your family. You stand in his place. You now take care of his children, you take care of his wives, you hunt for them, you bring this back into balance, and you mend this, and you apologize, and as your family, we're going to give this family horses and medicines, and now we are joined together as a family. That's what your action did. So that's bringing into balance in the Lakota worldview. So these are the ways in which we handled disruptions in the community. And there was always a ceremonial aspect as well. So the worst punishment for an indigenous person was banishment, because our whole world is kinship. You know your identity by your clan, who you're related to, just very strong relationships. And so for those that were banished, for my people anyway, they did something horribly wrong. And for us, some of the worst offenses were stealing, because we were a sharing culture. We would mark them with a knife cut across their nose, and so you could see them. And they became known as the Cuthead Dakota. There were a few of them. So that was the worst punishment we could do, is send you away from your people. We always had organizations and governance to maintain order and balance. We had the clan system, and certain clans were responsible at certain times of the year for different activities. We also had like a law enforcement clan and patrolling clan. And then we had societies, and societies are based on being invited into the membership. So these weren't something that were assumed. You had to live a certain way and then be invited in to become one of them. And our mediators and elders would be mutually agreed upon. They would be people who lived and exemplified these types of societies. So we had that as very strong. We knew how to handle these things, even when it was what would now be called murder, and bring it back into balance. And so we need to revitalize that. So as we look at sources of Indigenous laws today, we have cultural accounts, we have stories, oral histories, legends as primary sources. And one thing that we need to do in this generation is to start making text and audio recordings to establish our records. And with any kind of judicial system or dispute resolution, there has to be an opportunity to interpret and debate. And law is not static, you know that. Law is fluid. It changes as social mores change, as norms change, and the same for Indigenous communities. Some of these principles we may want to change today, but we have to have them in a place where everyone can engage with them. And also, if you're going to be brought into any kind of dispute resolution system, you're going to want to know what's going to be applied to you. So that's a challenge for our generation. There's been, a huge disruption through the policies of assimilation and the Indian Act of 1876 with the residential schools. So that's cut off culture, that's cut off language, that's cut off healthy community. And that suppression means that now we need to go back and revitalize. It's going to take time, but I think people are ready for that. And also to reclaim the authority of our traditions, put into practice in a routine court setting. And that's what I'm proposing today. So speaking of the Indian Act, there was a provision, Section 107, that talked about appointing justices of the peace. So the justice of the peace would be an Aboriginal person on a reserve, and they would have authority for any offense under the Indian Act. And then it also talks about certain ones under the criminal code. So I'll talk about statistics and how many were appointed, but there's a 1979 report that's easy to find out there to INAC, and it said there's a lot of issues with this, and this is in 1979. There's questions on whether or not provincial criminal law can be enforced, and really the way that justices of the peace are used, they're just swearing information, summonses, and warrants. There can be different training or inadequate training and inadequate funding and compensation. We're talking, a few dollars here to do this. Under Section 107, I've been talking to the Aboriginal Justice Division and trying to get statistics. Here's the best I can get at this point. Is from 1973 to 1999, there were 12 Justices of the Peace appointed in at least 3 First Nation communities. So again, this isn't quite public information yet, and it needs to be. INAC decided in 1999 to cease making appointments. Some of the reasons given, there's no structure to support. Tenure was an issue, compensation, there was no training, weren't sure about what discipline would come into existence. Currently, I believe there may still be 2 Justices of the Peace out there, but the program is defunct and INAC is not planning to appoint any more. But Section 107 gave rise to the Aquaskwaia Court. So the Aquaskwaia Court, I say, is a model here to look at. They have unique challenges because their reserve straddles Ontario and Quebec in Canada, and then also New York on the US side. And they found it particularly hard for their members to have to go to Ontario and Quebec and pay fees in both court systems for a restraining order or for any kind of a divorce order, anything that was happening where there was movement back and forth on the reserve, but you're in two different provinces. So now with the Aquaskwaia Court, you pay once and then they handle the relationship with the other two jurisdictions. It actually started with the Section 107 Justices of the Peace program, and they continue to do their own training. They set up judges and lawyers to come in and train their Justices of the Peace, and some of the statistics I heard there was that they would train 19 people and then select one. So it was a rigorous process. Over the past 17 years, the community has become more accepting. So with a formal court process, there's going to be legitimacy issues always. And that still is true in the US as well. This isn't the way in which we set up our dispute resolution, to have somebody in the sole decision maker role passing judgment. But it is a model that we can build on and use now to make sure that we are in control of how justice is meted out in our communities and how domestic issues are handled. So the council formalized the court, which has been in existence for 40 years, August 16, 2015, and that just entered into force in 2016. But this is it. This is the one in Canada that actually is involving First Nation people at every level and bringing in First Nation legal principles. They have a restorative justice approach, but they're still having issues trying to make it acceptable to both the federal level and then the two provinces they work with. The matrimonial property law they have has been recognized by the federal government, but there's not a mechanism at present for Ontario and Quebec to recognize orders from the Aquaskwaia courts. So if you want to have some fun, there's a court to go work in. They need it. But they are the trailblazers here. Why is this so important?
The council that formalized the court, is it the band council?
Mm-hmm.
Okay.
Well, there's a crisis, and people are aware of it. There's a crisis of over-incarceration of Aboriginal people in Canada. And from this crisis, there have been some responses, but I'm going to say that those are very limited responses, and they're not meeting the challenge of this issue. So you have Parliament enacting Section 718.2E in the Criminal Code, saying that you'll take into consideration the following principles if you're the judge with an Aboriginal person in front of you. All available sanctions or options other than imprisonment that are reasonable, with particular attention to the circumstances of Aboriginal offenders. And then R.V. Gluedo comes out in 1999, says there's an affirmative obligation to obtain pre-sentencing reports on, and they use this language, of the offender and on available rehabilitative and relevant programs. So this gets translated into Gluedo reports. So Gluedo reports have to be requested and received by the judge. And so now we're seeing lots of different organizations coming forward. In Thunder Bay, we have the Thunder Bay Indian Friendship Center that has Gluedo writers. We have the Anishinaabe Nation Legal Services that has Gluedo writers. Some of my law students are being trained in as Gluedo writers. And the Gluedo report, I think, is kind of traumatizing. So it goes through your family history and the legacy of residential schools, colonization, genocide, all of these things, and then brings it down to your life and your experiences, and it's a public record. And then that goes before the court in terms of sentencing. So there's guilt that's part of this process, and the idea here is is there another way to handle actions of Aboriginal peoples that would be labeled crimes without it being incarceration? And then we have critics. So a big one is that the judges just aren't asking for them. They're not being submitted, or they're not even read. They're not being taken into consideration. Other criticism is that this is really a sentencing discount for Aboriginal people. So not taking in the historical issues or what's going on in individual people's lives. And that sentencing won't address overrepresentation. And the court acknowledges that this isn't the only thing that needs to happen, but it's a step in the right direction. So that's what we're really talking about, are steps in the right direction. So you have heard about Gluedo courts now being possible. Let me just run through the whole thing and then we'll do Q&A, okay? So now there's Gluedo courts and First Nation courts, and I want to talk a little bit about those. But even with Gluedo in place, we're not seeing incarceration rates declining. They're increasing. Overrepresentation, and I've given you some statistics here, and then particularly troubling, I think, is the fact that women are really overrepresented in sentencing and provincial and federal incarcerations. So the Gluedo courts are intended to be a way for judges to take the guilty plea and then look at the Gluedo Report and bring in programs. We also see things called First Nation courts, and the main one that I'm familiar with is in New Westminster, British Columbia, where there's a video on YouTube if you want to check it out. The justice that has a lot of oversight in that, Justice Garth Smith, is going to be coming and talking to us at our law school about his court. But again, it's still an arm of the provincial court system, still based on the criminal code, and there's a lot of reluctance for Crown attorneys to agree for a file to go into Gluedo court or the First Nation court. And you have people looking at the system saying, if it's meant to address over-incarceration, then there shouldn't be implied cap on the type of offense it's addressing. Because the offense it's addressing, if it's one that people would, as judges, automatically think this is something that would require jail time, and so it's now not available to these types of courts, you aren't ever going to address overrepresentation in incarceration for Aboriginal peoples. It must deal with serious offenses too. It must. And that's been the reluctance with judges and Crown attorneys. And so if it's a minor offense, then going to these courts is sort of okay sometimes, but that'll never address over-incarceration if it doesn't deal with every type of offense. And so that's why I'm saying these are just minor steps. I'm also saying it's perpetuating that external method of punishments. That this is not like the community coming forward and helping the person or understanding the person's background and history and bringing in support. When you take somebody out of the community, you also are having repercussions to the community. Some people say that when you do that, not only are you stopping the community from coming back together, but you're also not having the person take responsibility. They serve time and then they come in and they can reoffend. So it's not addressing all the basic values of how do we get to the root of this human behavior, not the symptoms, and have recidivism. So arms of the Canadian court system, and I'm here to say, I don't think this is going to solve the problem. So I want to talk about a US model. So I talked about that pendulum swing. So that's how we talk about what we call federal Indian law in the United States. We talk about a pendulum swinging from the nation-to-nation relationship with treaty making, then to what we call the removal era. So this idea that once the British colonies revolt, the United States is formed, that the Indian problem will go away if everybody's moved west of the Mississippi. So that's tried, but it doesn't work, right? So with the removal era, we say it swings back, and there's some disagreement about this, to the reservation era, which overlaps in time. But with the reservation era, the reservation is understood, like I told you in Ex parte Crow Dog, as the homeland, as the jurisdiction of the people who live there, and that self-government is assumed. So that's why it's said to be a pendulum swing back. But then we get assimilation. And assimilation is what we call the boarding schools. This model has been picked up in Canada as the residential schools. And it actually started, I don't know how many of you know this story, but it actually starts with Geronimo. Geronimo is an Apache leader, and the U.S. Cavalry cannot bring him in. And they start hiring his distant relatives to bring him in, and they finally do. And when they do, they want to punish him and his entire family. So they grab everybody that they think is related to him. They put him on trains and take him to Florida. And they hold him there at a fort in Florida, and they do this militarization training. And General Richard Pratt is in charge of that, and then he goes to Pennsylvania and starts the first boarding school, Carlisle Indian Boarding School. And then that report is sent and picked up in Canada by INAC. So it was a way to bring Geronimo under control, and then it gets used across North America. All right, so assimilation is the worst era where the pendulum's swinging. It swings back though in 1934. In 1934, the Indian Reorganization Act is passed. And this does not have a counterpart in Canadian law. And so I'm saying this deserves serious study here. The Indian Reorganization Act rolls out tribal constitutions. And so every tribe has the option of adopting a tribal constitution. It also rolls out federal charters for corporations. So once a tribal nation charters their corporation, it's a federal charter, and it takes an act of Congress to uncharter. So there are several tribal nations that have done this because they see it as a strong economic framework. But it's a statement of self-government and recognition by the United States. It's legislation, and some tribal nations opted out. The Navajo Nation is the largest population reservation in the U.S., and they also don't have a written constitution, but they have their principles of Navajo law, and they have a court system and a Supreme Court system. And so the right to exercise self-government is assumed in the U.S., and these tribal constitutions are just expressions of that. We need more empirical data. We don't have good empirical data, but I talked to our chairperson of the Tribal Judges Association and asked for a stat, and the stat was there's approximately 350 plus tribal courts in operation in the United States. So if you don't establish a tribal court, there's two things that could happen, and we'll talk about it in the next slide as we go into the history here. But this whole idea that you have self-government, that you set up your own court system, that you pass your own laws, is everyday and ordinary in the U.S. for tribes. And I think that needs to happen for First Nations. So in the 1800s, the U.S. started creating what were called CFR Courts, Code of Federal Regulation Courts, and these were instruments of assimilation. So the Code of Federal Regulations at the time outlawed cultural practices. Medicine men could be jailed indefinitely until they renounced their faith. This was part of incarcerating people who resisted having their children taken to boarding school. So really bad stuff, the CFR courts. With the 1934 Act, that's where the constitutions then were able to incorporate tribal court systems and establish them through tribal law. But there's still some legitimacy issues there, I will say, in some tribal communities saying, look, these were instruments of repression, like we can say about law, right? That's sort of an internal struggle all of us face when we're Indigenous people and go into law schools now, is how do we take this where we know it's been used in such a negative way to our communities and make it into something positive and helpful, at least a conversation. So tribal courts are from the sovereign power of the tribal nation and the sometimes tribal constitutions. There are a few remaining CFR courts, mostly in Oklahoma, but the codes are now much narrower and typical offenses, and it's just those tribes have the ability to do it. They just don't feel like they want to put their resources in that direction. So the default, if you don't establish your own tribal court, can be either that you ask for a CFR court or your tribal council can act as a court. But you always have that jurisdiction within your territory. All right, so tribal courts employ tribal laws. The hierarchy of persuasive authority starts with other tribal courts, then is federal, and then is state. The other thing tribal courts do is they may use what we would call indigenous sources of law for usually domestic law. There is a push by the U.S. Congress to make tribal courts more and more like state courts. Recently, with the Amnesty International report on violence against Native women, there was an amendment made to VAWA, the Violence Against Women Act, to allow tribal courts jurisdiction over domestic violence offenders who are non-indigenous, which is a huge step in the U.S. So for criminal jurisdiction, most tribal courts are limited only over other Indians. So it's tribal member Indians or any other Indian that's in the homeland, in the reserve. Because there's lots of intermarriage. We're kinship people, right? So lots of intermarriage. But this is very new. This has just happened in the last 3 years. So we're waiting for the constitutional challenge and to see how the U.S. Supreme Court deals with that and whether or not they're going to recognize tribal courts as a foreign system or whether they're going to say, nope, the structures are in place for due process. All right. So I think that this is a way forward. I'm going to give you just a sense of some of those tribal court sales just to make it a reality in your mind. I've had the good fortune, and a lot of times if you're a Indigenous law scholar in the U.S., and you work at a law school as a law professor, you're asked to sit either on an appellate bench for a tribal court or be a pro tem judge. I've done both, but it's an expected role. Both Indigenous and non-Indigenous people are tribal court judges and appellate justices. And for the non-Indigenous people, the expectation is they're going to sit down and really get to know the community. So I always say to be a good lawyer for an Indigenous community, you need to be a walking encyclopedia. You need to know all areas of substantive law that are taught in law school, as well as the history and the relationships for that particular people. And those are the expectations then to be a judge. But normalized, we need to normalize it here. So back to the Canada model, there needs to be this recognition there's a fundamental right to resolve disputes by First Nation people, by Aboriginal governance. The RCAP report in 1996 has this quote, there can be no peace or harmony unless there's justice, and they also proposed a nation model of government. So with the Indian Act, people were broken into very small band councils, hundreds of them, and then small territories. And we are seeing through some of the recent court litigation this rejoining together of nations, people that understood themselves as nations. So talking about my people, the Dakota, in the state that's South Dakota, there's 9 reservations, but we're all the same people. And we're having a hard time coming together, and from time to time we have the Great Sioux Tribal Council, and then it breaks apart, and then it comes back together. And we've been talking about having a Supreme Court for years, and haven't been yet. We're going through a healing process, but we have to continue to bring these ideas forward and say there are creative solutions here, and we can do this. So with this proposed nation model of government, all three branches are represented: legislative, executive, and judicial. And there's your citation if you want to take this up and keep talking about it. So there was no relinquishment of self-governance on the part of First Nations, and that has to be recognized. So what's the vision? I would say bring forward that recap nation model of jurisdictions and have these First Nation community courts. Not everyone has to agree to everything, but there can be pilot projects, there can be people starting this conversation. Have to record and figure out how to put down the legal principles from Indigenous law. That's going to be a challenge going forward, talking to the elders, figuring out what can we write down, what can we make available. Oh, I have to touch the screen, right? What can we make available? And then I say there should be both criminal and civil jurisdiction. That's the only way you're going to address over incarceration is if Aboriginal people are in their own First Nation community courts and they're able to bring back into balance whatever the behavior is that is being addressed as criminal. All right? And then again, there needs to be Indigenous appellate structures, and that's one of the criticisms I have right now for the self-government agreements, is that if you have an appellate structure that can overturn all your decisions, what's the point of having the court in the first place? So I think there's a real legitimacy issue there with the way that's being rolled out. And then my last statement, court systems are a necessary function of governance, and I should see no disagreement with a room full of lawyers and law students. Governance and domestic order for stability and community rebuilding. First Nations must be able to govern and provide formal dispute forums. So that's my presentation for you today. Thank you. I'm ready for questions. That good brought you to silence. Come on, I know you have some questions. Yes?
I'm wondering what an Indigenous model of an appellate structure would look like. Because obviously our administrative law is filled with ideas about reasonableness versus correctness, and we have a very particular way of viewing the rightness or wrongness of how decisions are made. And I'm wondering how you would apply that to a decision-making process that takes into account a lot of different things than a normal process, or our standard process would do.
Okay, so you would have civil appellate rules, and like I said, in the U.S. we have this. We also have, so not every tribal nation wants to fund an appellate structure. So what we have is regional ones. So we have the Southwest Indian appellate judges. For my people, the Sisseton-Wahpeton Dakota, our appellate structure is the Northern Plains Judicial Appellate Court. And like I said, we're trying to do a Sioux Supreme Court, but we haven't got there yet. But you're going to have your rules of appellate practice, and that's going to tell you how to look at the underlying law, what standards you're going to use. For the most part, I will say that the tribal courts are less rigid in terms of procedure than the state or the federal courts, and I would assume that would be true as well for First Nation community courts. But it'd be looking at, was there fairness? Was there any level of bias? Was there due process? Were the principles clearly stated? And you're also going to have whatever's being brought on appeal. The issues are going to be brought to you of what they felt was the miscarriage of justice. So those are the kind of principles I put in place. Yes?
I'm curious to know how it's funded in the States and how it might be funded here when we don't have enough government money for clean water in communities and food.
Yeah, so in the U.S., tribal economics is really the main resource. There are federal grants within the Department of Justice, which would be like the Minister Attorney General here. There is a tribal justice director, and there are grants there for tribal courts. But it is really self-funded. And then that's another reason to have those regional appellate structures, so everybody chips in. Yes?
I wonder if you could elaborate a little bit, about the 1934 Indian Reorganization Act. you mentioned how there is no parallel legislation in Canada. I wonder what would be the steps to bring that about, or what were the steps that historically brought the American government willing to sacrifice its power, its coercive power, which I assume it did in the Indigenous Reorganization Act, and how can such a parallel process take place in Canada?
Good question, good question. So in 1928, Congress commissioned the Merriam Report. It's named after Lewis Merriam. And Lewis Merriam reported on boarding schools. And he reported on the tragic conditions. And he reported on how the children are treated. And so you have that similar process happening now with the Truth and Reconciliation Commission. And so that was on the minds of lawmakers. And then the Indian Affairs Commissioner who was appointed, his name was John Collier. And John Collier had a fascination with Pueblo nations in the Southwest and spent a lot of time with them. So communication, and cared about them, and saw what was happening with the boarding schools. And as he became Indian Affairs Commissioner, he authored the Indian Reorganization Act. And it's a diluted version that was enacted, but it was strong enough to keep the tribal constitutions in there and the economic part. And so one of the arguments in my intro, you might have heard economics. So my filter, my perception, my scholarship is largely based on the quality of life for Indigenous people. And so I always look at what's the economics behind it. So the first relationships were really trading relationships. The Hudson Bay Company was the precursor to the British Crown coming in. And so it was always about economics and revenue, and that has to be readjusted for our people to be healthy again. And so if we're going to start doing cost-benefit analysis, we need to say how much is over-incarceration cost in Canada? Not only in terms of dollars, but in terms of morality, in terms of, do you want to wake up every day and listen to the news and hear about these awful stories about what's happening with Aboriginal peoples? Do you want to hear about entrenched and embedded poverty? At what point as a society do people come together and say it's worthwhile to reinvest and bring everyone up to a standard that we can now say, yes, we're a country about human rights? All right? So what happened in 1934 in the United States was John Collier became the champion of, we cannot say that we are a democracy and we stand for the pursuit of happiness and the equality of man when we're doing this to another people. And so that was the momentum that passed the Indian Reorganization Act. So the Truth and Reconciliation, the calls to action, this is a moment where I think people are becoming aware, and that awareness, I hope, will then lead to concrete solutions. Yes?
In the U.S., are members of those bands, are they U.S. citizens and can they invoke the Bill of Rights and proceedings on reserve?
So yes and no. So in 1924, the Snyder Act was passed, which naturalized all American Indians. Some say against our will. We claim dual citizenship, so within our tribal nation and with the United States. But becoming U.S. citizens and then also state citizens. So the U.S. Bill of Rights and the U.S. Constitution were enacted without tribal nation participation. So we have a very old case called Talton versus Mays in the 1800s that say the Bill of Rights do not apply in Indian country. And that's a legal term of art for us, Indian country reserves. And then the tribal government relationship with tribal citizens through the tribal court and those processes, it's in the Constitution. So there'll be a miniature Bill of Rights. One of the things, though, that's very true for us is that our spirituality is intertwined with our lives. And so you won't necessarily see religious freedom laid out the same way. In terms of the tribal court system, one of the critiques is that not all of the Bill of Rights that are available for U.S. citizens are available in tribal courts. The guarantee of a public defender is not there, but most tribal courts employ one. I was a public defender for 2 tribal courts. So you can't walk into a tribal court and say, here's my US Bill of Rights. That's not operable. But you can bring forward arguments that this should be the way in which this tribal court handles these kinds of rights, and then it becomes embedded in the jurisprudence for the tribal court. That's been one of the reluctant areas to allow tribal courts to have criminal jurisdiction over non-members, and that's why VAWA was such a huge leap forward. Yep.
Just to follow up, is it similar, is the thinking around what should happen in Canada and similar to that model, or is it different?
I think we're just going to
Because
start the conversation and talk about the right of self-government, the right of dispute resolution, and then can we join together and start doing piloting on some of the court systems and have Indigenous law be brought into those. I think that's all part of it. I know there's conversations about the charter and whether or not that applies and how that might work. Those are conversations that I think the communities have to have. And so that whole legitimacy thing, it can't be external. It's got to be internal, and it's got to be legitimate from the community's perspective. Everybody's ready to be a First Nation community court judge, right? Lots of work for lawyers.
Excellent. Well, please join me in saying thank you again to Dean EagleWoman for joining us and sharing her knowledge with us. It's so interesting. I have a lot of questions, but feel really insecure to ask them because I know so little about this, and so I'll ask you when it's not in front of a group of people and on the record. So that's the advantage I have of doing my job. So thank you very much.
Absolutely. Thank you.